Without going any further, I would like to open the first panel for the day. That is a topic on something which is very close to the hearts of the Pakistani economy, China-Pakistan Economic Corridor, Constructing the Future. I would like to welcome the moderator of the panel, Ms. Virginie, who happens to be a partner at LMS Legal London, and she will be speaking on navigating CPEC construction disputes with the two E's that are efficacy and efficiency. In your round of applause, Ms. Virginie. In this panel, our first speaker will be Mr. Zubair Ejaz, Chief Executive Officer of Astral Constructors, Islamabad, and he will be highlighting and discussing on the Chinese and Pakistani landscape and the requirements for neutral nationals on CPEC disputes. In your round of applause, Mr. Zubair Ejaz. Our second speaker in this panel will be Mr. Faisal Daud Pota, who is a partner at Daud Pota International, Karachi. He will be speaking on dispute resolution under the 1998 Energy Charter Treaty. In your round of applause, Mr. Faisal Daud Pota, please. Our next speaker in this panel is Mr. Haider Waheed, who is the founding partner at HWP Law, and he will be speaking on the next steps before arbitration and litigation, harnessing multi-tier ADR clauses and dispute boards in CPEC construction projects. In your round of applause, Mr. Haider Waheed, please. Our second last speaker in this panel is Mr. Charles Brown, who is the managing partner of Charles Brown & Company based in the UK. He will be speaking on paving the path, proactive dispute resolution management in the CPEC construction projects. In your round of applause, Mr. Charles Brown, please. And our last speaker in this panel is Honorable Mr. Justice Shakil Ahmed, the judge of the Peshawar High Court, and he will be highlighting and discussing on the integrating dispute avoidance in Pakistani court system. In your round of applause, Mr. Justice Shakil Ahmed, please. With this, I'll hand over it to Virginie, who will take it further from here. Thank you.
Good morning. I'm very glad to be again in Pakistan. This is my third trip in this wonderful country, and thank you very much for your attendance this morning. As you already have been told, the very first panel of our conference, the PIDW, is CPEC Constructing the Future, One Resolution a Day. This panel will focus on the China-Pakistan Economic Corridor, that is CPEC, which refers to a 3,000-kilometer infrastructure network project undertaken in Pakistan as part of the Belt and Road Initiative, a global infrastructure development strategy adopted by the Chinese government in 2013 to invest in major infrastructure projects and international organizations worldwide. Examples of CPEC projects are, for whom do not have any knowledge of those projects, is the Sahiwal coal-fired power plant, a coal power plant project located in the province of Punjab, operating since October 2017. Another example is Suki Kinari hydropower project, a run-of-the-river hydropower project located on the Kunhar River, expected to be completed by the end of 2024. So these are projects of billions of dollars, and they are for the benefit of Pakistan and also the neighboring countries, and worldwide, in fact, for the benefit of every human being. For infrastructure projects, a key issue is how disputes can be avoided and resolved. And this is the key question that we want to address with our panel from different standpoints. So the relationship between the various entities involved in a project at different level may lead to significant tensions. And I refer, for example, to the relationships between the main contractor and the subcontractor, between the main contractor and the employer, and the contractors who are part of the same joint venture who are responsible for the works, the relationship between the funders and the employer and the various contractors who are involved in the project. And these tensions will be addressed by Mr. Zubair Ajaz. The role of the state entities and the government is also relevant because the relationship between the foreign investors and the host state may lead to disputes and arbitration proceedings based on investment treaties. And with respect to China, there are two main treaties, the China-Pakistan Bilateral Investment Treaty in force since the 30 September 1990, and the China-Pakistan Free Trade Agreement, which is in force since the 1st of July 2007. But most of these investment treaties have similar provisions, and some of the aspects deriving from arbitrations or disputes based on investment treaties will be covered by Mr. Faisal Daoud Porta, especially with reference to investment treaties signed by the members of the Organization of Islamic Conference, the OIC. In resolving these disputes, practitioners are important, and this is not only practitioners, for example, from the engineering, architecture experience, but also lawyers. And how lawyers and other kinds of practitioners may be involved, they can assist, is also an important aspect and must be developed in Pakistan for having the necessary know-how and experience and knowledge. And this is an issue that will be covered by Mr. Haider Wahid. Practitioners will assist through a multi-tier dispute clause that are often agreed in the contracts by the parties to discourage a full-blown litigation or arbitration procedure, as Charles Brown will explain as part of the panel today. Many contracts are in fact based in Pakistan on the FIDIC Red Book 2017, which provides for a multi-tier dispute resolution mechanism with different steps. The first, an engineer determination. The second, dispute avoidance adjudication board. The third, amicable settlement, and then you have arbitration. So how you go from one step to another is something that Mr. Charles Brown will explain. At the end, the Honorable Mr. Justice Shakid Ahmad, who will describe how it is possible to promote dispute avoidance in the Pakistani court system, will be part of our panel, and the discussion will be coordinated by me as a result of my many years of experience throughout several countries, such as the UK, where I'm based, France, Italy, the United States, Canada, and Qatar. And you have here many examples of individuals from the MENA region, and especially from Qatar, who can in fact suggest and give impressions and experience from the various disputes that Qatar has seen in the last few years. So let's start with Mr. Zubair Ajaz, who will address problems faced by Pakistani subcontractors in CPEC projects and possible methods of dispute resolution. Mr. Zubair Ajaz is, has an engineering degree from the Imperial College London and an MBA in International Business from California State University. He has 45 years of experience working in the construction industry in Pakistan and abroad. He is presently the CEO of Astral Constructors Limited, a premier construction company in Pakistan, and Mr. Ajaz has previously held corporate positions in the United States as Director Mobile Satellite System at Hughes, and senior technical positions at Alcatel and GTE SpaceNet. Mr. Ajaz also led the reform of the telecom sector in Pakistan in the mid-1990s, which led to the establishment of the legal and regulatory framework in Pakistan and the privatization of the PTCL. Mr. Ajaz advised on similar reforms in other countries, such as Iraq, Haiti, and South Africa. So we are very pleased to have him part of our panel. And the first question I would like to ask him, for which I would also encourage your participation, is could you please give us an overview, Mr. Ajaz, of the operations of Pakistani construction companies under today's prevalent contracting landscape, and perhaps compare it with your experience in other countries?
Thank you, Virginie. I'm really grateful for all the kind words. And thank you, PIDW, for inviting me. It's definitely an intimidating session here with so many high-powered people. Sorry, can you hear? With such a heavy horsepower. I will do my best to give a basic landscape of construction industry in Pakistan as we understand it, in the business, as a company that mostly focuses on the non-government sector. We have chosen to, not go into a lot of the government projects because first of all, we don't do any horizontal work. We do mostly vertical construction, and there aren't too many government projects of the size that we wanted to focus on. However, issues we have in Pakistan in general apply across the board, in my view, to all projects, regardless of the size, in terms of contracts. The overall landscape, if we can break it down into three components: the government component, the private sector, and then what I call the third one, which is basically foreign entities working in Pakistan, embassies, Aga Khan Foundation, World Bank, those kind of institutions, or organizations that are developing projects in Pakistan. There are a number of companies that are working in Pakistan. 18 is one of them. They do a lot of big development in Islamabad. There's Imad that is working in Karachi. So the overall landscape that you see here is that you have contracts which are different for pretty much every project. Now, I think there have been a lot of attempts to pull all these things together. Of course, there are the guidelines for government projects from the PPRAs, the Public Procurement Regulatory Authorities. Those are also now split between the federal and the state regulatory authorities, but they are guidelines based on which the government comes up with their own contracts for individual departments of the government. In the private sector, it's the same thing. Every client has their own set of contracts, their own set of terms, and the attempt has been made several times, I'd say, unsuccessfully maybe, but there is a standard document that is in place for contracts that is available at the Pakistan Engineering Council, which is the regulator for the whole construction sector. But that is not really followed across the board, for sure, not followed across the board, but is rarely followed by anybody. So the question arises, why is it that we are not able to come up with a single or a small set of contracts that are the basis for work going forward, whether it's a large project or a small one? I think it's very hard to sort of explain to people who are used to working in, like you are, in a country where the universe of opportunities is really very large. I'm a construction company, there are 500 projects out there, and I can just focus on the 10 that make sense to me because the contract terms are in favor of the way I want to do my work. That unfortunately is not the case in Pakistan. We don't have a large number of projects available from where I can select what suits me and what suits somebody else. So we all end up bidding for projects and not being in a position to challenge any significant terms in the draft contracts being offered, because we know that if I challenge a particular section, I will not be able to get the job because somebody else who's also desperate to get a piece of the pie will probably accept it and move on. And it does happen in the industry. So what we do, and I'm not saying this is the right approach, but what we do is we basically take the risk. We will go ahead with the assumption that the terms in the contract will never come to fruition because you're just getting your job done, you're doing your work, you're getting paid, you're getting, and the contract ends. In a lot of cases it does. But there are problems that happen in every contract, and there are certain, the nature of certain problems which are grouped together. For example, a typical private sector entity that has decided to put up a skyscraper. Now, they have done all their homework. They have engaged a designer that does all the numbers and does the design and everything. So they come up with their business case on the basis of all that homework that was done. Now, it turns out that during the process, there is an issue and there is a major variation order coming up. Now, this private sector entity is has not budgeted for that extra expense. So we end up in a dispute situation. So it's a strange, in my view, it's a very strange dispute because it should be obvious that if something which was not in the design, we are doing that, somebody's got to pay for it. But then they go into dispute about, oh, on the one hand, you were late on this thing, so can we not, accept this thing, give us a bigger lift, and because we didn't have the budget for this particular size of lift and stuff like that. So those are things that we do come up with, and in most cases, I think I'd say for most contractors here, they don't go into any kind of litigation. They try and resolve it. Personally, Astral has never been in any litigation. There's another reason which I think is very important and is very frustrating, is that even if there is absolutely no reason for you not to go into litigation, it's your right, you've got a problem or dispute resolution. The fact that every pre-qualification document requires you to state whether you are in litigation, were in litigation, is enough for me to say, just let go, because we cannot afford not to be qualified, by somebody, because in the pre-qualification we stated that we are in a dispute situation. So those are kind of issues that we have in Pakistan, and I think going towards solution, yes, we do need an Arbitration Act for sure, which I think we have now. However, I don't know, I'm not a lawyer, I'm an engineer, so let me make sure that I don't say anything which is kind of obvious to the legal community, but if there is a clause in a contract that we have that can be overridden by another statute or some other mechanism, so that we don't have to worry about the fact that I have a very tight clause here that I can actually go to court and say, hey, you cannot actually enforce this on me because there is another overriding statute. So I think something like that would be required to take some of this fear out of contractors to go in and ask for their rights. So that's basically what my
but
my
let me
idea is.
comment in one way, referring to what you just said. When you draft a contract, there is a major misconception here. The lawyer does not invent a solution in the contract to make problems. That's the first thing. The contract is drafted in order to reflect what is the commercial tensions between the parties. So when you have a contractor and an employer signing the main contract, or for example the contractor and the subcontractor signing the subcontract agreement, the reason you have some clauses that are difficult is because you are trying to find a middle ground between the position of the commercial position of the parties. And the problem is that indeed, usually the liabilities and the financial costs are very often pushed down to the supply chain. So from the employer to the contractor, from the contractor to the subcontractor. And so the contractors are mostly suffering the consequences of and taking the risks. And that's the problem. But I would like to know from you, this is a universal problem. It's not just an issue in Pakistan. But the focus of the attention should be the fact that the project must be completed because it's for the benefit of everyone, for the society and the various entities which intervenes in the process. Yeah. So a reasonable degree of collaboration must be established so that the risks are not pushed down. So what do you think about the relationship between contractors and the client?
Okay, I think it's a good question. I know that where you're coming from, that question makes a lot of sense. Okay. But from where I am, it doesn't make a lot of sense for several reasons. One of them is that, as I mentioned, that the pie is so small that the clients, in most cases, I shouldn't say clients, the advisors, the consultants who prepared all these documents, they pretty much know that, hey, they're all going to bid. Anybody who qualifies in terms of their size and stuff, they will bid because they don't have a choice. I think the second thing is, as far as I understand, the industry, the construction industry, from a client perspective, in Pakistan is not leveraged at all. I don't know of any project that I worked on where a project was conceived from money borrowed from the banks or borrowed from somebody else. So there's no, it sounds very strange to, I know I've talked to people from other countries to find it very strange, but the reality is that because it's not leveraged, the desire to get the project done on time is not really as powerful as it would be in some other countries. Like, in England, nobody just says, okay, here's $20 million, build me something. It's always, there's a bank behind it that, funds it. We don't have that in Pakistan. So yeah, the client is just not pressured. Things are getting delayed. You would think common sense would tell you, hey, if you're building a hotel and you're 6 months late, you lost 6 months of revenue. But it doesn't work in Pakistan. I just don't know how to explain that, but it doesn't work. We've worked on lots of projects which are late, and I have had discussions with guys saying, look, this is such a small dispute. If for you, it's a small amount, but for us, it's a percentage of our profits, which are already quite low. Why are you letting this thing go on and on? But, that's the way it is. I don't know who agrees with me, but that's how I see it.
But for example, in projects, in CPEC projects, there is a funding there. Maybe it's not a bank, it's a Chinese government, financing its own banks. But the Pakistani government also invests some money into it, or in any event, some resources, and all the private business is also involved. And I understand that Pakistani contractors in those kind of projects are involved only as subcontractors.
Right.
So they are, again, suffering a situation, they are placed in a situation where they take the risks, and the issue that you just explained is not necessarily the same, right?
Yes. So subcontracting, we do very little subcontracting, but we have done it. Subcontracting carries the risk of the prime contractor passing things back and forth between the client and the subcontractor. I'm talking about a major subcontractor. And that's also, in most subcontracts, it's written in a way that a problem that they have with the client, they just pass it on to the subcontractors. And so now that gets even more complicated. Now you have to worry about the contractor and sort the mess out with him. And then you have to also worry about the client, because in the end it's the client that wants that thing done. And a lot of these things are based on, design issues. We don't have, again, cultural thing, but design coordination in Pakistan is a big problem. We do not, as a contracting construction company, we do not normally get well-coordinated designs. So we know going in that there's going to be problems. But what can you do? You have to take the job. As I said, again, it's the same thing. You have a pie that so many people are after that you don't have a choice.
No, so I could have a solution. It's a matter of organization and putting the priority where it should stand. So, in fact, you as a subcontractor or contractor do not have a power. And when the design is given to you, you just have to accept as it is. But for example, in many different countries, if I understood correctly your question, the contractor has the duty to refine the design and to identify problems and communicate those problems to the employer. And if you are a subcontractor, you have that obligation also with respect to the main contractor. And it's an obligation that comes from the law. So if you see that the design is not fit for purpose, so it doesn't really allows you to realize what is in fact the purpose of your project, then you have the obligation of developing or correcting or communicating the errors in the design. So why, for example, you do not feel that in your position you would not do that?
Okay, I'm going to be hated by a lot of people when I answer this question, but another cultural thing that we found, maybe we don't know how to do things right, but what we found is that when you start documenting stuff, which is what is required,
yes.
For us to cover ourselves from any potential risks, is not liked. Design. If you try and document something that questions a missing duct in a building because you realize that there's a problem here, the designer is not going to be very happy with you, and the designers mostly are also the people who are managing the project. So you have to, you actually have to play this game. I don't know how many construction people are out here who can maybe agree with me. Then you have to play this game of how do you solve the problem without documenting too much even against the, forget about the client, but if you're a subcontractor, against the prime contractor or the designer. Because the risk of offending the person and thereby making things worse down the road is quite high. And I think, again, we go back to the fact that you took a contract which in the first place was heavily not in your favor because you had no choice. So you kind of, it's a game we all play.
No, I don't have any questions. I was just saying he's off the hook very easy.
Okay. All right. So in addition to the rules of contractors and employers and funders, we have also the role of the state entities and the state. So when, for example, there are promises based on international treaties that are made by the host state, and when there is a foreign investor involved, which is the case in the CPEC most of the times, then you might have disputes that arise not only from the contract itself, but also from the treaty. Mr. Daud Potter will explain us what are the possible claims that we might have based on investment treaties. And he will base his explanation on disputes and members between the members from the OIC. Could you please?
Thank you very much, Virginie. I'm the first one to do the presentation, so I have to get a little bit of visuals and a little bit of attraction for everybody to get to understand what is investor-state arbitration. There are so many bilateral investment treaties. There are so many multilateral investment treaties, more so the ones that Virginie mentioned, the ones between China and Pakistan, the ones between the investors that come into the CPEC engagement. They rely on their country's bilateral investment treaties with Pakistan. or the multilateral investment treaties that Pakistan has. The very first bilateral treaty that was ever signed in the world actually was in 1959. That was between Pakistan and Germany. And more or less, these bilateral investment treaties have similar provisions, which we will quickly touch base. I won't go into a lot of detail because I have to speak very fast, run very fast, and we won't have enough time for Q&As. So there is a built-in arbitration clause in a bilateral investment treaty. We'll come to that as to why do we need to have a signed agreement and why a signed agreement doesn't really matter when there is a treaty-based arbitration that provides a cause of action for arbitration. If you see, we will go through a few things. I won't repeat what is written on the slides. You can read faster than what I speak. The fun fact is that Pakistan received a notice last year from Saudi investor, and they are relying on a cause of action that arises from the OIC arbitration treaty. It is not because of the agreement between the K Electric. It is not because of the agreement between the K Electric and the investing authorities, or the consortium in this case. And that is no longer an ad hoc arbitration. They have an arbitration center now set up in Istanbul, Turkey. A little bit of flashback. The Recodic case, the cause of action was based on Article 12 of the Australia and Pakistan arbitration bilateral investment treaty. It was not based on the Chaghi Hill exploration joint venture agreement. The Supreme Court declared the joint venture agreement is invalid back in 2019, but the ICSID assumed jurisdiction based on the cause of action that was based on the treaty-based arbitration. You cannot invalidate a treaty because there is a Vienna Convention. Anybody else? Everybody knows that Vienna Convention on the laws of treaty. So it's not easy to back out from a treaty unless you renounce the treaty, unless you abrogate the legislation that transposes that in your jurisdiction. So with that, of a little bit of glimpse into what investor-state arbitration is all about. It's not based on just in the agreement. Anybody who wants to know where the treaty is based, this is a multilateral investment treaty. You can download it from the OIC website. It has all the provisions. I'll just highlight a few of them, which is Article 17 of the OIC investment agreement, which is agreement for the promotion, protection and guarantee of the investment. It was signed back in 1998 or 89, I believe. And it gives you a definition of investor. It gives you a definition of investment. I've highlighted the operative part of the definition in a paraphrased manner, which gives it's a contracting party. It can be a government. It can be a private party from the outside. Hence the earlier slide of a Saudi private consortium sending a notice to the government of Pakistan. Oh, we have a dispute. Well, we rely on the arbitration that arises from the treaty, not from our agreement. And then you have a definition of a capital. Capital is what they have transferred in, which is their assets, which is the profits, as well as the dispute. Sometimes arbitration agreements do have a definition of a dispute. Sometimes they don't. This one does not have. This is the bilateral investment agreement. This is the multilateral investment agreement. In this particular instance, the definition of dispute doesn't exist, but of course, when there is a breach of the provisions of the multilateral investment agreement, that does provide a cause of action to the investor. There are a few ways which we will highlight as to what kind of breaches. Host state is very much vulnerable. It has to treat all the investors in a very, non-discriminating manner, even-handed manner. So it can be, where they are not providing, enough permit. I have to read up my slide to turn around. Where they fails to provide the permit to transfer the capital, they are failing to open up various field of investment. The host state fails to provide necessary facilities for residents' work and all that stuff, logistical support, as well as the host state fails to respect the rights that have accrued to the investor over the period of the agreement, as they earlier to that and before that. The Chaghi Hill Agreement was signed back in 1993. The treaty was signed between Australia and Pakistan in 1998. The cause of action arose in 2011. So there's a whole mix of things that make things fuzzy when it comes to the investor-state arbitration. Going to the next slide. Oh, yeah. There are certain guarantees that the host state has to afford safeguards for, and with respect to the investor. It comes to the transfer of capital, because there's a Foreign Exchange Regulation Act, as everybody remembers that, in Pakistan. 1947, created around Second World War time, that restricts foreign exchange. That is a penal statute. That is not a statute that manages foreign exchange. So a lot of investors face that kind of challenge. So those kind of provisions actually come against the state when it comes to transfer of capital, because they find themselves handicapped. Then you have the freedom to dispose of property, as well as monetary compensation where the state has itself violated any international law or something. Yep, I'm almost done. Then you have a state that is treating investor in a discriminatory manner, and those are the causes of action. I won't go through all of them. And then there are certain defenses. One of the important defenses that a state can take is that they have done their own part, and there are certain obligations that the investor needs to do. So his own conduct is contributing to his damage and injury. Those are the things. But not in all instances that you have all the defenses available. Last two slides. And there are ways to address when you are in a dispute. When you are a state, you cannot hide. You cannot, you are there. Any enforcement of judgment is very easy to be enforced against you and your assets around the world. So it's better to settle rather than fight. Don't spend a lot of money on litigation when you can find a solution in an amicable manner. Your settlements are private. Your settlements are not public. Arbitration awards are public announcements, and they can take years to conclude. The arbitration awards are are costly also. You cannot predict the amount of award. You had $6 billion of award coming out of the RICO one. You have a $400 million claim coming from the Saudis under the OIC cause of action, and we are almost done.
But let's move with Mr. Haider Wahid, and let's see what are the main areas and causes of construction disputes in Pakistan, and how can these disputes be reduced or mitigated?
Honorable judges, dignitaries, ladies and gentlemen, I have the small role of talking about the role of Pakistani practitioners in international construction contracts. Only a brief overview would be possible. So let's see if I have this. There you go. So I'm going to talk a little bit about what the agenda would be very quickly. There you go. So we'll start with what international construction contracts are in Pakistan, the main areas of disputes, the standard forms of contracts, the 2017 FIDIC conditions. We'll talk about the dispute resolution mechanisms found in international construction contracts, what the law says and what the reality is, the role of the Pakistani practitioners, cultural and legal aspects. The way forward, we've got the arbitration bill of 2024. I have applied my mind to it somewhat, but I'm greatly benefited by the scholarship of Justice Miagul of Thursday evening. So I'll be talking a little bit about how that compares to the 1940 Act and how we are probably fortunate if this can be enacted into law. I'll also talk a little bit about the FIDIC conditions of 2017 and how we need to really fast adopt those. So what is an international construction contract in Pakistan? It has to have international elements, international parties, directly or through a local subsidiary, international forums, a court or arbitration, perhaps the choice of law and the provisions of a different country, although that's a bit contentious. International construction contracts in Pakistan. Large international construction contracts in Pakistan involving especially Chinese contractors and construction firms. Some of them I've listed. There's one of them, the dredging and reclamation at Pakistan Deepwater Container Port, Karachi Port Trust contract that I was a part of as a lawyer as well. Moving quickly to the main areas of construction disputes. Well, not surprisingly, payment delays. Payment delays are 10% of the disputes. Extension of time is 10% of the disputes. Behavior and competency of people happens to be 9%, and this pie chart pretty much covers the remaining areas of dispute. International construction contracts in Pakistan, the standard forms of contracts, unfortunately, although we've made progress, there is almost no instance of the 2017 FIDIC conditions being incorporated. 34% of contracts are using the FIDIC conditions of the 20th century. 22% are still using the 1987 FIDIC conditions. So we definitely need to move on to the 2017 FIDIC conditions, the important features of which are the provision of dispute avoidance and adjudication boards, the DAAB. What used to be the DAB has now added avoidance. Emphasis on preemptively resolving disputes. Advance warning provisions, parties are required to inform each other of potential future events impacting the project. It's much like a relationship, like any relationship. If we keep each other informed, if we communicate, then potential future events and disputes can be avoided, not adjudicated, but avoided. Extension of time. Contractors in the 2017 FIDIC conditions are no longer required to submit a separate extension of time for variations in the scope of projects and works. The reduction of the period of the amicable settlement to 28 days is another important feature of the 2017 FIDIC conditions. Non-compliance with the DAAB decision allows direct referral now to arbitration, bypassing the amicable settlement period. The role of the engineer expands in claims resolutions. Engineer can facilitate agreements between parties. Neutrality of the engineer has been particularly emphasized in this respect, and that's particularly a problem in Pakistan, the confidence in an impartial engineer. What is the dispute resolution mechanism in construction contracts in law? So there's a multi-tier ADR clauses in FIDIC contracts, the engineer's decision, the dispute adjudication board, this is pre-2017 conditions, the dispute avoidance and adjudication board, which is now in the 2017 conditions. There's negotiation, mediation, and then, of course, arbitration. General conditions are often amended through the particular conditions of the contract. And of course, local parties are free to modify those conditions. Of course, the more formal and more constant we are, the greater the confidence of the international investor. The dispute resolution mechanism in reality this did surprise me. So there is a study that says that only 7% are aware of dispute avoidance boards. There's something that needs to change because prevention is better than cure. We've heard that all our lives. Primary focus remains on negotiation and relationship management. So 63% basically resolve their disputes through relationship management and joint contract reviews and negotiations. Dispute resolution mechanisms in reality, also surprisingly, that negotiation with other parties still constitute 50% of dispute resolutions in international construction contracts, a figure that did surprise me. I'll come very quickly because you're staring me down now, so I'll come to the role of the practitioner. I believe that a lawyer should welcome this ADR, this push towards ADR, and this progressive approach that especially the judiciary has taken. And I think it had to start from the judiciary. I mean, everyone would have to follow the lead taken by the superior judiciary of the country, and no less than the senior puisne judge of the Supreme Court of Pakistan, in particular, Mr. Justice Mansoor Ali Shah. Progressive approaches would obviously mean adopting the 2017 FIDIC conditions, which include the provisions for dispute avoidance and adjudication boards, advance warning provisions, and DAAB decisions, which are expressly binding on the engineer. So lawyers must advise their clients to adopt these provisions, the ADR clauses, the multi-tier system, the 2017 FIDIC conditions, and of course, the new Arbitration Act that I'll very quickly come to. The role of the Pakistani practitioner can be to serve as a co-arbitration counsel, serve as experts on Pakistani law, perform factual investigations, effect court-assisted gathering of evidence, witness testimony, obtain pre-arbitral interim relief from local courts, And legal and so I think the biggest hurdle in the way of ADR comes from our cultural bias. But because of this huge push now towards ADR, I hope that this culture can evolve because there are 2.4 to 2.6 billion pending cases, and really the legal system is choked, and which is probably why we're taking this very, very seriously. Now, coming to the progress, the new arbitration bill of 2024 is a pro-arbitration, has many pro-arbitration provisions. It has less room for judicial intervention, narrowly defined grounds for challenging an award. The Pakistan Engineering Council has happily now incorporated in the standard bidding documents of December 2023, the 2017 FIDIC Red Book, which will be which was notified and effective as of the 1st of April of 2024, which is good news. And of course, Pakistan is gearing up to sign the Singapore Convention on Mediation, the framework for enforcement of international settlement agreements. Coming very quickly just to, like I...
Please conclude.
Okay, well, it's a good thing that Justice Miyagul has already educated us on the Arbitration Act and Arbitration Act of 1940. It's the judicial intervention that has been done away with. It's the decree, it's how the arbitration award automatically becomes a decree and so on. So I'll have to stop here, but certainly there is promise now because of this push towards ADR, because of the Act, the FIDIC contract, the FIDIC conditions of 2017, and the culture that I feel is definitely now evolving. Thank you.
Thank you very much, Mr. Wahid. We have Mr. Charles Brown now that will focus on how to deal with the multi-tier clauses for our own benefit. The word for you, please.
Good morning. Thank you very much for inviting me to this very important conference. I've crossed out most of what I was going to say because time is very short. In preparing for today, I was hugely impressed by the report from 2022. Some of the data in that and the analysis I think is absolutely first class and says so much about the state of the construction industry in Pakistan. And as I think we've heard already, 97% of construction contracts in Pakistan often have some form of dispute. But only 8% of them involve sums of over 500 million rupees, which is not actually very much. Most, as you've heard, of the international style of contracts feature the FIDIC form of contract, but a very old edition, not the current one. And the importance of the current one, as again was said just now, is that it doesn't have a dispute adjudication board, far less a dispute avoidance and adjudication board. The FIDIC procedure for contracts that do have such provisions is that first there is a decision from an engineer, which is not accepted by a contractor. That leads to a notice of dissatisfaction and triggers the involvement of the board, usually 3 persons, selected for their impartiality and expertise at the start of the contract. The board members are paid a monthly retainer and are expected to visit the project on a regular basis and are there and therefore are up to date if and when disputes or problems turn into disputes. The important new feature is that the board will provide recommendations when requested to solutions and solutions to problems before those problems turn into disputes. The result of that is that the board will probably have fewer disputes to deal with, and therefore this form of multi-tiered procedure is intended to avoid rather than encourage the creation of disputes. So that's the purpose of it, and the whole process has to be completed in a period of 84 days, which is relatively fast, but not as fast as I'll say in a moment, the alternatives, as far as I'm concerned. You can play around with this. make a requirement that before anything happens, senior named representatives of the parties have to have a discussion and try to see if they can settle it. You can undoubtedly involve, and should involve, mediation provisions. And you can have what FIDIC calls an amicable settlement attempt. So all of these can be added to the mix. The Islamabad court has looked at issues relating to compliance with such pre-arbitral steps in a FIDIC construction contract and concluded that any attempt to bypass these procedures should be discouraged, not permitted, which is, again, a good example of court support for the processes of ADR. However, there is a big cautionary note that our first speaker was absolutely right to emphasize. The size of the project. It's all very well if the project is for $100 million, you can afford a dispute board. You probably can't afford a dispute board for much less. One of the FIDIC president list of adjudicators has provided a very useful costing for a 3-person board in place for 24 months. If you take the monthly retainers over that period, you're talking nearly $470,000. He estimates that each dispute, if and when it comes along, will cost $200,000 on top. Now, I had some knowledge of a very large dispute board, which ran over 5 years, a very high-value metro project. There were a total of 58 individual disputes that the board looked at over a 3-year period. On my calculation, the cost of that DAB would comfortably exceed $12 million. So your project needs to be for a very large sum of money if you're going to really get into proper use of dispute boards. Those are the main points I wanted to make about multi-tiered dispute resolution procedures, but I did want to just end with a couple of comments endorsing the opening comments about the genuine support and encouragement of the judiciary in the construction sector. I think it is absolutely critical to the reduction of disputes that the judiciary support. I would offer one or two very humble suggestions. In addition to the repeal of the 1940 Arbitration Act, I think it might be useful to look at the 1872 Contract Act, which I understand permits something called pay-when-paid clauses. Now that pay-when-paid clauses, in my experience, are a recipe, a breeding ground for disputes. So I would say that that's an area that would be great if you could get rid of it. The other thing I think that's worth considering is, as has been done in a number of common law jurisdictions, the introduction of statutory, so the legislature's got to be involved, statutory fast-track adjudication. Give contractors and owners, employers, a statutory right to refer any dispute to fast-track 28-day adjudication by a nominated or appointed adjudicator. The decision is temporally binding pending subsequent litigation or arbitration. And here comes the bit for the courts. The courts, certainly in the UK, have restricted their involvement to the process of enforcing adjudicators' decisions if the losing party fails to comply with the decision. And the courts in the UK have said there are only 2 grounds that we will not enforce. Exceeding your jurisdiction as adjudicator or breach of the rules of natural justice. Those are the only 2 grounds. And I think anything that the judiciary can do to discourage parties that go to ADR ending up in litigation is to be encouraged.
Thank you very much, Mr. Brown. In fact, let's have our final remarks with the Honorable Mr. Justice Shakil Ahmad. I have some questions for you already prepared, And we would like to, first of all, thank you very much for attending our conference. So our first question is, what pre-litigation steps the courts can implement as dispute avoidance methods?
Thank you very much. In the name of Almighty Allah, who is most beneficent and most merciful, the honorable judges, the lawyers, the distinguished guests, Assalamu alaikum. I will try to be more precise due to paucity of time. I stand here before you to address a crucial aspect of our legal system that often goes unnoticed but holds immense potential to transform our approach to justice, integrating dispute avoidance mechanism in Pakistan courts system in a country where a legal battles can be protracted, costly, and emotionally draining. It's imperative that we explore alternative avenues to resolve dispute efficiently and effectively. Pakistan's court system faces numerous challenges, ranging from backlog of cases to resource constraints. The backlog of the cases often leads to prolonged wait times for litigants, adding to their frustration and disillusionment with the legal process. Moreover, the adversarial nature of traditional litigation can exacerbate conflicts rather than resolve them amicably. Dispute avoidance mechanism offer a proactive approach to resolving conflicts before they escalate into full-blown legal battles. By promoting communication, collaboration, and compromise, these mechanisms empower parties to find mutually acceptable solutions without the need for formal adjudication. Not only does this save time and resources, but it also preserves relationship and promotes a culture of cooperation within the society. There are several dispute avoidance mechanisms that can be integrated into Pakistan's court system, each offering unique benefits tailored to the needs of the parties involved in the litigation. These are mediation. Mediation involves a neutral third party facilitation discussions between the parties to help them reach a mutually acceptable agreement. Unlike a judge, the mediator does not impose a decision, but empowers the parties to craft their own solution, thereby promoting ownership and buy-in. In our rural and backward area, we find Jarga system, Panchayat system in Punjab, and the people of the backward area or rural area recognize and acknowledge this practice as a better way of dispensation of justice. This system may be made more effective by making some suitable amendments in the relevant law. Arbitration offers a more formalized process where an impartial arbitrator hears the arguments and evidence presented by both the parties and renders a binding decision. While arbitration resembles traditional litigation in some respects, it offers great flexibility and confidentiality, making it an attractive option for resolving commercial disputes. Negotiation. Negotiation is perhaps the simplest form of dispute resolution, involving direct communication between the parties to reach a settlement by encouraging open dialogue and creative problems solving. Negotiation can often lead to mutually beneficial outcome without the need for third-party intervention. Then comes the role of technology. In an increasing digital world, technology can play a pivotal role in enhancing access to dispute avoidance mechanism. Online platforms can facilitate remote mediation and arbitration, allowing parties to participate from anywhere with an internet connection. Furthermore, technology can streamline administrative tasks such as scheduling, hearing, and exchanging documents, thereby reducing delays and ineffectiveness in the dispute resolution process. While the integration of the dispute avoidance mechanism holds immense promise, it is not without its challenges. Cultural attitude towards conflict resolution, lack of awareness about alternative options, and the need for specialized training for the judges, lawyers, court staff, and mediators and arbitrators are just a few hurdles that must be overcome. That by following these steps in Pakistan can establish an effective dispute avoidance court system, reducing the burden on traditional courts and providing citizens with faster, more efficient, and cost-effective dispute resolution. Let us seize this opportunity to embrace innovation, foster dialogue, and build a future where justice is accessible to all. Thank you very much. Thank you.
So this is our conclusions, in fact, for our first panel. I hope you had the first introduction to the various debates that will be developed towards the day today and tomorrow. And we are all available, and I invite you for any kind of questions you might have following up our presentations and debate. And I invite you to applause all the speakers who have been quite pressed by time, but have made in any event their presentation. Thank you very much.